public participation in a constitutional amendment process and the standard of public participation in a constitutional amendment. Then the commentaries on the Justice and Legal Affairs Committee report, a role of the court in a constitutional amendment process, and finally, justiciability, ripeness, mootness of the petitions as presented before the Superior Court. All these issues together will be addressed by my learned friend, Senior Counsel Otiende Amolo, and Senior Counsel Lucy Kambuni. Now, Your Lordships and Your Ladyship, I wanted to start these submissions as a first principle to deal with the Constitution itself, particularly Article 1, Sub-Article 1, because I think this forms the framework under which this Constitution can be interpreted correctly. And a lot of the other issues that are dealt with, including basic structure and the sovereignty of the people, if they are read together with Article 1, Sub-Article 1 of the Constitution, then it will make some sense. And I want to submit that even the question that was asked by Justice Toyota about the people, a reading of section Article 1, Sub-Article 1, together with the preamble, will answer that question. Now, in saying this, I want to ask this question. Does the Constitution of Kenya create a situation where the people as sovereign exist outside the Constitution or within the Constitution? That is a very important question for your Lordships to address. Because the manner in which the court dealt with the question of basic structure is as if the people, being sovereign, can exist outside the Constitution. They can operate outside the Constitution. And the answer to this question is that they cannot, under this Constitution. Even with the sovereign power and the sovereign will, the people have to obey and comply with the Constitution. And this is clear from Article 1, Sub-Article 1. And if you allow me, my Lord and Your Ladyship, it says, all sovereign power belongs to the people of Kenya and shall be exercised only, I emphasize the word only, in accordance with this Constitution. So as the people exercise sovereign power, they have to do it within the Constitution. And I think that the trial court got this wrong from the very beginning. They were imagining a world where the people existed outside the Constitution. And this is very clear even in the preamble, because the people in enacting and adopting the Constitution were adopting for themselves, it says in the Constitution. We adopt it to ourselves and for future generations. And the second point to make on this question is that this Constitution, Article 2, Sub-Article 1, this Constitution is the supreme law of the Republic and binds all persons. It binds all persons. And no person within may claim or exercise state authority as authorized under this Constitution. What am I trying to say, Your Lordships? And if ever the court thought about context and about what the Constitution making was all about, it was to provide a lasting peace and a form of governance that would create a truly democratic and just society that abided by the rule of law. You cannot, by constitutional contrivance, elevate national values, and which include the rule of law, and when it comes to the sovereign, the people, you say that because they are sovereign, then they can have an existence outside the Constitution. That, under this Constitution, it is not possible. My Lord, if that were true, because all power is donated by the sovereign, including judicial authority, my Lord, your powers are donated, judicial authority. And this is not a thing that has never happened in this country before. When Jiku can come to this court and say, now you have to surrender judicial authority to me, and you judges must retire because we are sovereign. My Lord, that is not how a democratic society, which is based on the values spelled out in Article 10, can operate. And therefore, having said this, my Lord, there was my ladies, there was a French philosopher and historian and writer whom I like quoting all the time, Voltaire. Voltaire once said, and he was a deist, he believes in deism, which means he believed in God, the existence of God. He said, if God did not exist, it would be necessary to create one. The court, the trial court, because they were so anxious about applicability of the basic structure doctrine, they had to create it. They had to invent it. Because nowhere does it exist in the Constitution. And we can go through how they did that. And they had to go to a wonderland. My Lord, sometimes you see a movie or a novel which is so compelling, but at the beginning you're warned that the events you're about to see are not true. Or the characters referred to are not real. My Lord, this court should have warned that as we deal with this matter, it does not exist in the Constitution, which eventually they did say, that there are no explicit provision covering the issue of basic structure. And I want to say the question of basic structure, really in every society, even a dictatorship, there's a basic structure. Even in a theocracy, there's a basic structure. If you go to the Roman Curia, the Papal Curia, there's a basic structure there which has gone for centuries. Even in a military dictatorship, there's a basic structure. In the United States, before the Emancipation Declaration, slavery was part of the structure of American society until the emancipation. Before the amendment of Section 2A, if you read Section 2A in the retired Constitution, the one-party system was part of the basic structure. It said so. The question is amendability. The question is amendability, which my other friend Paul Mwangi is going to talk about. In dealing with this question of basic structure, in order to answer that question, which the judges never did it in any part of the judgment, they decided, and that is in page. My Lord, in answering that question, it's very interesting. If you look from page 141, paragraph 393, they're dealing with the question of the basic structure, doctrine, and its application to Kenya. And they come to the conclusion, if I come to the right page, in order to deal with this question, what guides the court to deal with this question of basic structure? Is it the Constitution? The answer is page 41, paragraph 41, I'm so sorry, in page 148. We think, I quote, "We think that the appropriate response to this question can only be given after one fully understands the history of the making of the Constitution of Kenya 2010. That history provides the appropriate context for answering the transcendental question posed." So, my Lord, they put the Constitution aside and demonstrate that when they're dealing with other questions in relation to the Constitution, they begin with the text. They set out the text. In fact, in order to make this point with some finality, my lords, if you look at, and this is in several pages where they deal with several questions to deal with the Constitution, they set out the text in the Constitution that they're going to deal with. My Lord, if you look at page 256,